In today's video, I'm going to tell you about a case that made it all the way to the Supreme Court that deals with debt collection attorneys. And it benefits you. So you're going to want to listen to this. It's very, very important. This is something that I've talked about in my other videos, and I'm going to elaborate on it more, and I'm going to give you the proof by telling you the exact case. Understanding and educating yourselves about what debt collection attorneys can do, regardless if they're buying debt and collecting it or they're representing original creditors or debt collection companies. You have rights, but you have to understand how to apply them or they're going to just disregard them. So let me ask you a quick question. This is something that I see a lot, and I even ran into this when I was going through my debt issues back in the 1990s. If you are going through something, we have this tendency, some of the words that are used is to clam up. We degrade down, and when I say degrade, it's not that like you're degrading yourself. What we do is we revert back to what's called a criterion value, where we go down to only caring about everything that can protect us and our way of life that we live right now. You stop thinking about progressing in this to doing something. We all kind of revert back into this protection mode. And when dealing with debt collectors, this is the one thing, you got to hear this lesson. When debt collectors are contacting you about a debt that you owe, or they're suing you about a debt that you owe, they know, you ever heard where an attorney doesn't ask a question that they don't already know the answer to? Well, how do you think that they get into that position? Is because they know that when people are confronted with being sued for a debt, or even a debt collection letter that is sent to their doorstep, to their mailbox, that they revert back and they start to think about protecting. And when you're thinking about protecting, it is very difficult to start to think about solutions, to start to even understand that you have rights. And even if you try to initiate your rights, something usually comes about to where people are not usually doing things in the right order. It's like a puzzle that's just out there. You've got a piece of this, and that's the right piece, and that's the right piece, and that's the right piece, but they start piecing them together the wrong way. And that's because the overarching mindset is to protect yourself against them taking money from your bank account, garnishing your wages, calling your boss, all of these things that can affect what you believe about yourself and your lifestyle. There was a case, and as I did my research, during this time period, they believed that this was a very pivotal case for the Supreme Court to help consumers that were being sued by attorneys, either representing original creditors or debt collectors. It's Heintz versus Jenkins. And it states here that this was a pivotal case that clarifies the application of the Fair Debt Collection Practices Act to attorneys engaged in consumer debt collection activities. This case expanded the scope of the Fair Debt Collection Practices Act to include attorneys who regularly engaged in debt collection as part of their practice, particularly when that activity involved litigation. Now, here's a little bit of background about the case. The dispute began when attorney Heintz, representing a bank, sent a demand letter to Jenkins, a borrower, regarding a delinquent loan. Jenkins responded by filing a lawsuit against Heintz, claiming that the demand letter violated the Fair Debt Collection Practices Act by making false statements about the amount that she owed. Specifically, Jenkins argued that Heintz had overstated the amount by including insurance costs, which she claimed she had not agreed to. Heintz argued that as an attorney engaged in litigation, he was exempt from the Fair Debt Collection Practices Act. The Fair Debt Collection Practices Act, originally enacted in 1977, had provisions amid at curbing abusive debt collection practices, but there was sorry about that. It was ambiguous about whether these provisions extended to lawyers involved in legal proceedings for debt collections. The key legal question for this case, the central question in Heintz versus Jenkins, was whether the Fair Debt Collection Practices Act definition of debt collector included attorneys who engaged in litigation to collect consumer debt. The Supreme Court ruled unanimously in favor of Jenkins, holding that the Fair Debt Collection Practices Act does indeed apply to attorneys who regularly engage in consumer collection activities, including those involved in debt-related litigation. Justice Sandra Day O'Connor, who wrote the opinion, pointed out that the language of the Fair Debt Collection Practices Act does not exempt attorneys. Therefore, attorneys who regularly pursue consumer debt collections are subject to the same standard as other debt collectors. Implications of the rulings. Application of the Fair Debt Collection Practices Act to attorneys. The decision confirms that attorneys involved in debt collection, even if their role involves legal representation in court, must comply with the Fair Debt Collection Practices Act. This includes avoiding false, misleading, or abusive practices when collecting a debt. Impact on legal practices. Post-Heintz, law firms specializing in debt collection had to adopt stricter compliance protocols to ensure they did not inadvertently violate the Fair Debt Collection Practices Act provisions. Any misrepresentation or overstatement of the amount owed, as alleged in the Jenkins case, could lead to FDCPA, Fair Debt Collection Practices Act, claims against attorneys. The ruling also strengthened consumer protections by ensuring that borrowers could bring FDCPA, Fair Debt Collection Practices Act, claims against attorneys who violate the act during litigation or related activities. Clarification of debt collectors defined. By including attorneys in the definition of debt collectors, the Supreme Court set up a precedent that the Fair Debt Collection Practices Act is a broad covering and variety of individuals and entities involved in debt collection. So this is the deal. When you are sued by an attorney that is representing the original creditor or debt collector, the part that they don't want you to know about, the part that they don't even want you to get into, is that you have a right to question that attorney. You have a right to say in writing, and you have to do this the right way, but that attorney, for them to be able to bring that to court, to bring that case to court, they have to have reviewed and made sure that that amount that is claimed is accurate. They get away with it a lot because what I said earlier, people go into that protection mode. And they might say, well, I don't owe this amount, but they don't know how to question the attorney. They may not even put it in their response in a way that questions the attorney. It's just, well, can you get more documents from the original creditor? You have to put it in the hands of that attorney because they brought that case. And according to the Fair Debt Collection Practices Act, they are working as a debt collector and they have to do what's called a debt validation, and they have to sign off on it. They have to sign off on it. So if you are being sued by a debt collector who is collecting for the original creditor, you have a right to do that. You question the debt collection attorney who is bringing the case. But now back to that puzzle where people are doing the right things, but they have it all in the wrong way. If you are being sued by an attorney for a debt to the original creditor or from a debt collector, you have to respond to that case. You can't just send them a letter. No, you can't just send them a debt validation. No, you have to respond to that court summons and you do your response in your affirmative defense, you would put those questions to that attorney in that affirmative defense to make sure that they did a debt validation. You need to put it in there, and you need to word it a specific way. If you receive a letter from a debt collection attorney, which you're not receiving it from a debt collection attorney, you're receiving it from a debt collection company that might be ran by an attorney, you have a right to send a debt validation and ask if that attorney, whoever the attorney they're going to put on the case, one of them, just pick one, have they reviewed to make sure that the amount that they're claiming in this debt collection letter is valid. That's why when they send the debt collection letter, they give you a right to dispute any or all of that debt collection letter, because that attorney knows if they send that letter and they were just to state, we know you owe this amount, and they don't even give you the chance to dispute, you would have them if any part of that debt was inaccurate. They're actually giving you the opportunity to question it, but people are questioning it the wrong way. What most people are doing is they're just saying, give me some documents. And the debt collection attorney, here's some documents. Here's some statements. Okay, Mr. or Mrs. Attorney, does the number that you sent in this debt collection letter, the number that you put in this court summons, that does not coincide with the documents that you sent. Show me something that's going to equal out to what you claim that I owe. You just saw, I just read it here in this Supreme Court case. Just a little difference in the amount would be considered. Let me get back to the notes here. The background of the case. The dispute began when attorney Heintz, representing a bank, sent the demand letter to Jenkins, a borrower, regarding a delinquent loan. Jenkins responded by filing a lawsuit against Heintz, claiming that the demand letter violated the Fair Debt Collection Practices Act by making false statements about the amount owed. How did she get to the amount owed? If the attorney got the amount from the bank, right? The attorney has a responsibility to make sure that that amount owed is the amount owed. And they can't just say, well, my client said this. No, they have to check that out. But it goes back to what I said. When you get sued by a debt collector, when you receive a letter from a debt collector, most people downgrade and go into protection mode. You can see that this woman looked at this letter for what it was and said, I don't owe this amount. How did you get that amount? And because you got that amount from an amount that I did not agree to, which stated here some insurance costs that they threw on top of there that she never agreed to, that ended up being a violation of the Fair Debt Collection Practices Act. That's a violation of the Fair Debt Collection Practices Act. Look at all of the different things that either these car dealer loans from these predatory lenders, some of these payday loans, some of these different credit cards that are high interest, these hard money payday loan places that people have gotten loans from, and they have these little insurance things on there that people didn't even really know that they were signing up for. And even if they signed up for them, they didn't even know the amounts of them. And stuff, numbers aren't adding up. And then when they get sued, they're like, this number, I don't even remember this number. Like, people sometimes think that people are lying when they say, I don't recall that number. And they're like, I don't recall that number. When I got sued, number one, I had a credit card when I was 18 years old when I was in the Army. And I was making $600 and some a month. No one was giving me a credit card that was going to allow me to charge $4,500. But when that card went bad, I, couldn't afford it. Whatever was going on when I was 18 in the Army, I didn't pay it. It was about $150. I didn't pay it. But later, Roush, Stern, and Hornick came and sued me for $4,500 on that credit card. And luckily, because I was in my 20s, I didn't know about this stuff. Luckily, I said, I don't owe you no $4,500. And it turns out that they had purchased the debt. And by me just making that statement, the judge was, I guess, a little bit, was very fair and said, you got to prove how you came up with that amount. Now, the attorney for Roush, Stern and Hornick was one of the junior attorneys. And then they said, we need more time to get these documents. And later, they said, okay, we're going to make the next hearing in 30 days. I had to go to this hearing. My wife was like, we can't pay $4,500. And I said, I did not owe $4,500. This was a debt that came about before we got together. I was like, I'm promising you, I didn't owe they didn't give me a card for $4,500. I was in the U.S. Army. I was in the military and I'm 18 years old. I did not have a card for $4,500. And so no matter what, I was going to these court hearings, and on the next hearing, they brought this big stack, like big, and it had all of these redactions, and then it had my name, and it had this, the amount was not shown on there. And they knew that they had just blown that up with fees and whatever they were doing. This is when this stuff was really getting rolling in the 1990s. And I said, I don't owe it. I don't owe that amount. The judge said, why don't y'all go in the back room and negotiate? And this was Attorney Roush. This was the big boss attorney. Still around. The big boss attorney. Nationwide now. He was just a local attorney at that time. I went back and forth with him. I said, I don't owe that amount of money. He said, what can we settle this for? I was like, I'll pay $500. Because I was just, for some reason, I just thought to myself, well, maybe it was $500. I wasn't even thinking right. I was in that protection mode. But because the amount was so high, I was in that mode of, I got to find a solution to this, because I can't go back home having to tell my wife we owe $4,500. Just couldn't do it. So we ended up settling for $500. And I remember I took the cashier's check straight to his office, and they they had all these protection things up. Now you know why debt collection attorneys sometimes sound scared, like they don't want to deal with nobody. They don't know if somebody's going to come in there and try to do something to them. And they were like, all this, you can slip the check through the cashier's check through there, and through the window thing. And when they got it, it was $500. They were like, he didn't do it. There's no way. You owe $4,500. There's no way he settled for $500. I was like, he did. And the attorney came in. The attorney came in. Now, listen to me, because this is a very important lesson that I'm getting to. And I'm getting to it, and I'm saying it this way because people don't just lay out solutions to you when they're actually, like, their body language gives you solution. And I'm saying it this way so you can understand how, if I was not in that protection mode, I could have really taken this attorney to task, which I've helped my clients do it in the future. So Attorney Roush came to the window and told his representative, and literally he said, get out of here. And he took it and said, thank you. Now, why was he so, when I look back, why was he so anxious to get it over with, make me sign the papers that everything was done and over, case was dismissed, and everybody, bygones be bygones. You can leave the office. It's all over. You won't see me again, hopefully. Is because what I didn't know was that the debt that I paid $500 for was past the legal statute of limitations to collect. I lived in Texas. I was in the United States Army in El Paso, Texas at that time, and the statute of limitations on the debt was 4 years, and it was past 4 years. And even in the state that I had moved to in Wisconsin, the statute of limitations on the debt was 6 years, and it was past the statute of limitations for collecting the debt. He did not want me to even understand. He didn't tell me. They didn't even say it in the call. Now, when they sent that debt collection letter, they had a responsibility to tell me that they could not pursue legal action on that debt. That debt collector, under the Fair Debt Collectors Practices Act, it states in there that a debt that is time barred, just the word that they use, time barred debt, that there is no legal remedy for it. All they can do is call you over and over and over. And then if you say cease and desist collection activities, cease and desist all calls and contacts, I'm not paying this debt. I know that this debt is past the legal statute of limitations to collect. They can't even, it's over. Game over. But I didn't know that. And he knew that. He knew it. And when I questioned that debt, when he showed up to the case, he did not want that junior attorney to say something wrong that would have triggered something with that judge. Because if I would have said anything about how old is this debt, he didn't know he didn't know what I didn't know. He could have been like, most people don't even question the debt. They just get up there and start questioning about how they're going to pay it. I triggered in him by asking them to validate the debt. And within them, they were like, this person might know something. He might know something. And what do they do when they, just like I said, we revert to protection? I didn't even get the signal. He reverted back because he knows about these cases. He's an attorney. He knows. And he reverted back himself. And he was like, I better get my butt in there so this junior attorney don't say something that's going to put this whole firm in jeopardy. And we did the back and forth. And when we did the back and forth, when I look back, it was so many signals. But I was not educated at that time. I was in my 20s. I wasn't even thinking about that. I was building my publishing company. My number one thing, protect money. Did not want to go home to my wife saying that we owe $4,500 on the debt that I made before we got together. So that was my protection status. Our business that we had built was starting to grow. It was catching. That's why I was able to just say, hey, $500, boom. Like there was no problem. Case over, done with. I go home. Family, that's over. Let's just move forward. That was my mode. But I didn't even pick up on the signals. So, this is what I need you to do. If you are being sued by a debt collector, if a debt collector is sending you letters in the mail for debt, either that they purchased or a debt for the original creditor, go to my website, thecreditrepairshop.com, in the live chat. Tell us what's going on. We have a service that will question that debt, and most of the time, they will cease all collection activities because that attorney is not confident on signing off on that debt. And yes, it could even work for original creditor debt. You just saw right here, this was from a bank, and this bank threw on some sort of insurance cost that this debtor did not agree to. It could be something as simple as that. So go to thecreditrepairshop.com, in the right bottom corner, live chat, put your information in there. It's worth it. I mean, it's literally saving you hundreds, if not thousands of dollars by simply responding the right way. If you're being sued by a debt collector, same thing. And upload your summons if you have it, and we can tell you how we can help you or give you some information on how you can help yourself. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. For you need your credit reports and scores, go to the website your3scores.com. Grab your TransUnion, Equifax, and Experian credit reports on all 3 scores. If you have debt collectors coming after you early in the game, grab my 3-pack of letters, statute of limitations letter, debt validation letter, and cease and desist collection activities letter. Use the one that's appropriate for your specific situation. Thank you for your time. Please subscribe to the channel, like this video, post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.